All members and guests to always please silence your cell phones. For those wishing to speak on a bill, I remind you there's a sign-up sheet at the podium by the door. Mr. Secretary, please call the roll.
Senator Carroll.
Here.
Senator Deneen. Senator Neal. Senator Nemes.
Present.
Senator Reed.
Here.
Senator Stivers. Senator Thomas.
Here.
Vice Chair Wheeler.
Here.
Chair Storm.
Here. We have a quorum. We're duly constituted to do business at this time. Do any members have any guests they'd like to introduce? Is Mr. Neil Voles in the audience? Okay. I was going to introduce him. He was is the Deputy Director of the Florida Rights Restoration Coalition, but I don't see him in the room. So at this time, we'll go ahead and proceed with Senate Bill 60, which is first on our agenda. That is an act relating to restoring religious liberty, sponsored by Senator Steve Rawlings. Senator, if you would, identify yourself and any guests, and you have the floor.
Thank you, Mr. Chairman. Steve Rawlings, Senate District 11, and I have with me Greg Baylor, and he can introduce himself after I speak. I'll defer to him. Appreciate the opportunity to bring this bill, and there is a committee substitute.
Motion on the sub.
Senator Wheeler with a motion on the sub. Do we have a second?
Second.
Second by Senator Carroll. All those in favor say aye.
Aye.
Any opposed say nay. The substitute is adopted. Please proceed.
All right. So what RFRA, this is our Religious Freedom Restoration Act, so commonly referred to as RFRAs. What RFRAs basically say is that government should be held to a very high level of proof before it interferes with someone's free exercise. We strongly believe that we can never be too diligent in this work. That is a quote from President Bill Clinton. In the preamble to our Kentucky Constitution, it states, "We, the people of the Commonwealth of Kentucky, grateful to Almighty God for the civil, political, and religious liberties we enjoy, and invoking the continuance of these blessings, do ordain and establish this Constitution." And further, Section 5 of our Constitution is entitled Right of Religious Freedom. The last sentence states, "No human authority shall, in any case whatever, control or interfere with the rights of conscience." Despite our Constitution, according to the Religious Liberties and States Index, Kentucky ranks 34th in the nation for religious liberty protections. And I saw another index that rated us at 28th, so it depends what you look at. But Senate Bill 60 will fortify religious liberty across the Commonwealth by ensuring that government actions do not place undue burdens on individuals' rights and religious practices. Senate Bill 60 seeks to amend KRS 446.350 to provide a clear legal framework for safeguarding religious freedoms. Key provisions include raising the evidentiary standards. Government actions that burden religious exercise must be justified by clear and convincing evidence of a compelling interest. And then there's expanded remedies. Individuals whose religious exercise has been burdened may seek appropriate relief, which shall include costs and attorney's fees. And then there is a sovereign immunity waiver. SB 60 allows individuals to sue the government for violations of religious liberty. Kentuckians should not be faced with unnecessary restrictions when exercising their sincerely held conscience and religious beliefs. Senate Bill 60 will provide a clear and stronger legal framework to protect religious freedoms from infringement from government actions. The passage of SB 60 is a commitment to having the correct standard to protect a fundamental right.
Motion on the bill. Doesn't stop.
I understand that Senator Wheeler did make a motion on the bill. I haven't heard a second yet, but there are some individuals that did sign up to speak. Are you finished with your presentation?
That'd be fine, yes.
Okay. So at this time, we'll allow those individuals that did sign up to speak to come up and speak. I think there was, if you signed up, there was 4, I think, that signed up.
we gotta move
One
over there
person
to
just
speak.
texted and said they were in another committee. Okay. So if you did sign up to speak on this bill, please come up, identify yourselves. And I think the senator took about around 3 minutes. If you could just try to be concise.
We will. Again,
Please identify yourself for the record.
yes, Chairman Chris Hartman, Executive Director of the Fairness Campaign. I don't relish being here 2 committee meetings in a row. And I do first, though, want to appreciate the bill's sponsor, Senator Rawlings, has been in communication with me. And while we may not agree on everything, I do appreciate it. So we faced this legislation last year in the House, and I'll say very similar things. The bill is very similar to the version from last year. Senate Bill 60 simply opens the door to jackpot justice for national interest groups like Alliance Defending Freedom, which I believe is here in the room today, to rake in millions of Kentucky tax dollars from local governments. Alliance Defending Freedom is eager to sue Kentucky cities and counties with local discrimination laws. We have 24 Kentucky communities with local fairness ordinances, and they seek to collect millions of Kentucky tax dollars in damages from those suits. Senate Bill 60 allows all state and local laws, ordinances, rules, regulations, and policies to be subverted by someone asserting religious freedom, including domestic violence laws, property laws, trespass laws, civil rights laws, contract laws, and so many more. If you proceed with this, we've proposed a simple change that would protect at least civil rights laws. I've sent you in the fact sheet that was emailed last night the language that we would ask that you consider amending Senate Bill 60 to include. I will also note, and I believe the ACLU has highlighted this in their message to you, that Senate Bill 60 adds such broad language that it could be used in lawsuits between private parties, forcing private litigants to prove the government's interest in enforcement of certain laws. I'll leave you with the fact that the majority of Kentucky voters oppose legislation like Senate Bill 60. We polled on this last year with a Mason-Dixon poll, which is linked in your packet. They agree that Alliance Defending Freedom doesn't deserve jackpot justice on Kentuckians' dimes, and so do I.
Please identify yourself for the record.
Mr. Chairman, thank you very much. My name is Sam Markison. I'm on the faculty at the Brandeis School of Law at the University of Louisville. And in a prior existence, a prior life, I was an attorney at the Equal Employment Opportunity Commission in Washington and was able to litigate many cases involving religious freedom on the side of asserting that freedom. And so I come to you today very much sympathetic to the idea that religious freedom needs to be protected, religious liberty against government intrusion or burdening. But Kentucky law already does that. We already have a Religious Freedom Restoration Act that requires the government to show that its actions are justified by a compelling interest when they place a substantial burden on religious freedom. What this bill does is go an unfortunate step further, and as Chris already said, burdens the ability of local governments to enforce effectively their anti-discrimination and other laws. And the question is, do we want religious freedom protections to be so absolute that they overcome any other considerations in policy that are important to the voters of the Commonwealth and to, I hope, this body as well? In balancing those considerations, I hope that the committee will take into account the interests on the other side and make sure that this bill does not result in local governments with anti-discrimination laws being afraid to enforce those laws for fear of being sued and having to pay substantial amounts to those who bring these suits. And the last thing I'll say about that is that many of the suits that have been brought by those asserting religious liberty against the application of anti-discrimination laws have been brought by individuals who had not even been the subject of an enforcement action, but they anticipated that they might be investigated or held to account for discriminatory practices. And if that is permitted under this bill, what will happen is local officials will be very hesitant at best and perhaps unwilling at worst to enforce anti-discrimination laws. And I'm confident that that is not the hope or the purpose of this committee, and will either amend the bill or reject it. Thank you.
Mr. Chair, Senators, good morning. My name is Rabbi Ben Fried. I'm a rabbi in Louisville, Kentucky at Knesset Israel Synagogue. And as a Jew and a rabbi, hopefully it doesn't surprise you that I am a big fan of religious freedom. It's one of the things that has made America one of the safest places in history for Jews. George Washington famously wrote a letter to the Hebrew congregation in Newport in which he said, "For happily the government of the United States gives to bigotry no sanction, to persecution no assistance." My concern with SB 60 is that while it is intended to advance the cause of religious freedom, it could end up allowing for bigotry and persecution under the guise of religious observance. I thank God that I live in a country and a commonwealth where we all have the right to believe whatever we believe and practice our religion as we see fit. But one of the things that makes America safe for religious minorities like my own is that the recognition that our own rights end at the point where we begin to harm others. As a religious minority that experiences an unfortunate level of hate, I am disturbed that SB 60 could be interpreted to supersede local anti-discrimination laws and ordinances. If a Christian landlord decided they did not want Jewish or Muslim tenants because our beliefs were abhorrent to them, would that be permissible under this bill? If a person were to aggressively solicit my synagogue, attempting to convert us, something that happens through mail and in person, to the point of harassment, but the police officer who arrived decided that his own religious views aligned with those who were doing the harassing, where would be our redress under this law? Could all parties not claim to have simply been operating under their sincerely held religious beliefs? As a Jew and as a rabbi, I'm not generally a fan of absolutes. There's an old joke that when you have two Jews in a room, you have three opinions. In Jewish texts of law and lore over the centuries, we are a multivocal tradition, and there is rarely unchallenged consensus. I, of course, understand that the First Amendment to the Constitution guarantees that the government make no law respecting an establishment of religion or prohibiting the free exercise thereof. But absolutism is dangerous, as evidenced by the fact that our rights do have limitations. For example, speech that incites violence is not protected, and the right of people to peacefully assemble is subject to all manner of time, manner, and place restrictions. If you are convinced that we in Kentucky are in need of more robust religious freedom protections, I implore you to add language to this bill that will explicitly state that it does not apply where a religious exemption could harm others. Make it clear that our right to religious freedom does not trump the rights of others to the same freedoms of life, liberty, and pursuit of happiness. I thank you for your time and consideration, and I hope that we find a way to continue to make this Commonwealth one in which religion is practiced freely while continuing to give bigotry no sanction and persecution no assistance.
Thank you for your presentation. Senator Wheeler, did you have a comment or a question?
Yeah, I guess one, I find the term jackpot justice highly pejorative and loaded and frankly offensive as an attorney out there that represents injured people on a regular basis. But secondly, Mr. Hartman, how many times have you sought your organization or people that you represented sought attorney's fees from the Commonwealth to enforce viewpoints that perhaps your organization or people that you feel are affected by laws of the Commonwealth when they feel discrimination?
Never.
Never. Okay, so you're not aware of any time that someone who's trying to
In my 16 years at the Fairness Campaign,
All right.
we've never been party to a suit.
You've never been party to a suit. Okay.
Not in this respect, no.
I guess second, and this may go to the gentleman seated to your left. I guess one question I have, you said that there could be a lawsuit by people that aren't even impacted yet. I mean, if they've not been impacted, I know about declaratory judgments and things like that, but I mean, I would think there would possibly be a standing issue if they've not suffered any. Would you not agree?
One might think so, Senator, and that is certainly the most common kind of lawsuit is somebody is the subject of an investigation or a lawsuit and says that that challenge to their practices impacts their religious freedom. But it is certainly not the only kind of suit. The Supreme Court's recent case, 303 Creative, involved a lawsuit brought by individuals who said that they had not been, no one had brought a case against them, no one had claimed them. The recent Louisville suit brought by Ms. Nelson involving her website was also a case where no one had filed a challenge to her. No one had claimed she discriminated, but she claimed that she anticipated that she would be challenged and that she would be accused of discriminating because of who she would be willing to provide her services to. And the courts therefore enjoined, the federal district court in Louisville enjoined enforcement of the Louisville Fairness Ordinance, which had never been applied to her. So this is what is happening frequently, even if it's not the only way in which these lawsuits are brought.
Thank you, Mr. Chair.
Senator Thomas.
May I have Senator Rawlings come back to the table? I have a couple of questions of him since it's a bill.
Are there any questions for these presenters? That's fine.
Thank you, Mr. Chair.
Thank you.
Please proceed.
Thank you, Mr. Chair. Senator Rawlings, if you don't mind, I have a couple of questions
Yes, sir.
to you. Okay. First of all, under this bill, if a school board decides that they want to enact immunity requirements, children have to take MMR vaccines or polio vaccines, and they do so because they think that that's a good idea, since those illnesses, those diseases can cause death or permanent harm to children. Would a school board now be subject to liability, subject to potential personal lawsuits? Because what really troubles me about this bill, being a lawyer, is the fact that it makes clear, even the sub, that exclusively for the purposes of this section, sovereign and governmental immunity are waived, which means not only can the school board be held liable, but the individuals would not have qualified immunity to raise these actions. So, answer my first question. Are school boards now prohibited from implementing vaccine regulations or requirements for children because under this religious liberty requirement in this bill?
I believe that those questions go outside the context of this bill, but if you don't mind, I'd like Attorney Baylor to answer that question.
I would prefer an attorney to answer it since I'm an attorney.
Senator Rawlings, if you could have your guests identify themselves.
Yeah.
Sure. My name is Greg Baylor. My name is Greg Baylor. I serve as senior counsel with Alliance Defending Freedom. Thank you for the opportunity to testify here. I appreciate your question, Senator Thomas. The Religious Freedom Restoration Act that's already in existence in Kentucky would play a factor in a situation like that. So suppose a school does require a vaccination and someone has an objection to that. Would they be able to avoid that vaccination based on the Religious Freedom Restoration Act? The answer is we don't know. The Religious Freedom Restoration Act does not dictate the outcome of particular cases. All that it does is it gives religious claimants an opportunity to present their case to the judge. There are a lot of folks who object to vaccines on non-religious grounds, and an objection like that would not enable them to invoke RFRA to avoid the vaccination requirement. Second, even if there was a burden on their religious exercise, the court always has the opportunity to deny the religious liberty claim based on the fact that there is a compelling governmental interest, and public health can be a compelling governmental interest. So it would depend on the facts, it would depend on the claimant.
And again, I realize that as lawyers we don't want to get into arguments, but we can agree that if this bill were to become law, certainly someone who wanted to pursue that interest would have a cause of action under Senate Bill 60 to assert that. And again, the courts could decide that. And the fact that governmental and sovereign immunity would be waived would be a chilling effect on potential governmental persons who'd want to implement such a vaccine requirement.
Well, it not to be a chilling effect if the government is confident that what it's doing is not violating religious liberty, or if it is justified by a sufficiently compelling interest. I think it's worth noting that we've had a Religious Freedom Restoration Act in the United States at the federal level since 1993. And so many of these hypotheses, these hypotheticals, these examples that are designed to scare us have not come about. We have 28 states with Religious Freedom Restoration Acts. We have 10 states that use strict scrutiny, which is essentially the same thing as a Religious Freedom Restoration Act. So we have a long track record, not only in Kentucky that's had a RFRA since 2013, but in the nation for over 30 years, and we haven't seen these kind of horror stories unfold.
Second question, Mr. Chair.
I think that's, you've already asked two.
Well, the second one was just a follow-up to
We
the
have
first
one last question.
Thank you, Mr. Chair.
That's it.
Senator Rollins, my second question is this, and I had a long talk last night with my distinguished colleague, Senator Berg, who I have a lot of respect for. If you had someone who, let's say, here's the question. The government has a provision that says one can't discriminate in the area of public not public service, but public accommodations, public sales. Like if you want to buy bakery goods, for example, they can't come in and say, we won't serve you because of your religion. Okay. Under this bill, if a bakery, someone to come in a gay couple, and they wanted to buy bakery goods, and there's this government law that prohibits that under the fairness ordinance, could that bakery now under this position, that bakery store owner, deny service to a gay couple who want to buy a wedding cake?
Well, these are questions that we're seeing around the United States, and it depends on a lot of factors. But again, I'd rather Attorney Baylor respond to that.
I'd rather an attorney answer that question.
Yeah, well, I am an attorney also, but
Okay,
he is
well,
more experienced.
Well, that's an excellent question, Senator. In these cases, what we find is the proprietor of these businesses is not turning away people because of who they are. They're turning away messages that they don't want to create. Jack Phillips of the Masterpiece Cake Shop in Lakewood, Colorado, welcomed gay customers. He sold baked goods to gay customers. He sold them to same-sex couples. What he would not do was to create a custom cake in celebration of a same-sex wedding, because that was inconsistent with his religious beliefs. That case went to the Supreme Court, and he prevailed because our court said that free speech is incredibly important. We need to respect it, and sometimes it overcomes competing interests. Under a Religious Freedom Restoration Act like the one that we have at the federal level, like we already have here in Kentucky, a businessman like Jack would have an additional argument under religious freedom. But again, it's always a balancing test. There's always an opportunity for a judge to say there is a compelling interest in eradicating discrimination. So the cases aren't predetermined.
I'm not sure a gay couple would be able to distinguish.
Thank you for your
Motion on the
presentation.
bill.
We have a
Renew my
motion
motion.
on the bill. Do we have a second by Senator Reed? Mr. Secretary, please call the roll.
Senator Carroll. Senator Deneen. Senator Neal. Senator Nemus.
Aye.
Senator Reed.
Aye, and I'd like to explain my vote.
Please limit to 2 minutes.
Thank you, Mr. Chairman. I don't mean to brag, but I am not a lawyer, and I suspect that's probably the reason why my leadership has given me the honor of being on this board or this committee. The Constitution, the way I understand it, is in place to protect the people from the government, not the government from the people. And with this bill, it seems like this gives we, the people, an ability to fight back. And for that, I appreciate it, and my vote is aye. Thank you, Mr. Chairman.
Senator Stivers. Senator Thomas.
Mr. Chair, I'd like to explain my no vote.
Please limit to 2 minutes.
Thank you. I think this is a dangerous bill for a number of reasons, but the biggest reason is the private right of action that exists that clearly goes beyond what we see in most statutes, because generally speaking, states are very restrictive in including private rights of actions, but this bill not only provides for private right of action, but it makes it clear that sovereign and governmental immunity are waived, which means that government officials could be sued personally. they would not have the defense of qualified immunity in this instance because of this section. And to add that to this bill really does chill and deter government officials from acting. I found this bill very dangerous for our society, really cuts against the equality and move toward a more diverse society that we're pushing for. And so therefore, for those reasons, Mr. Chair, I vote no.
Senator Wheeler,
Aye.
Chair Storm,
Aye. Senate Bill 60 is reported favorably with the expression of opinion that the same should pass. Thank you. Members, at this time, we're going to pass over Senate Bill 130 that was sponsored by Senator Maiden. So now we'll turn our attention to Senate Bill 169, which is last on our agenda, an act relating to administrative subpoenas sponsored by Senator Carroll. Senator Carroll, when you arrive at the table, if you could identify yourself and your guests, and the floor is yours.
Thank you, Mr. Chairman. I'm Danny Carroll, the state senator from the 2nd District.
Good morning, Mr. Chair, members of the committee. Will Schroeder, Senior Counsel for Attorney General Russell Coleman.
Good morning. My name is Matt Hedden. I'm the Special Victims Unit Director for the Attorney General's Office.
Mr. Chairman, for the first time in my career in Frankfort, I'm going to shut up and let the attorney speak.
Well, thank you. It's good to be here this morning. Senate Bill 169 is a modernization of law enforcement tools to help combat the war on children. In 2009, this honorable body gave the Attorney General's Office the ability to use administrative subpoenas during an investigation where there is reasonable cause to believe that an internet service provider was used in exploitation or attempted exploitation of children and limited cases of also in limited cases of online harassment. In 2013, this General Assembly expanded that just to Kentucky State Police to use the same tool to agencies that have statewide jurisdiction. This bill simply adds to the platform types where children are being exploited online to specifically include social networking companies, mobile payment services, or cloud storage services to the list. A lot has changed, as you all know, since 2009 in the world of technology, and this will allow the Attorney General's Office and Kentucky State Police to stay more up to date with tools that predators are using to contact children online. Similar to how a police officer can look up a license plate and see who the car belongs to, these administrative subpoenas only provide the account holder information associated with the account, such as electronic mail address, internet username, internet protocol address, name of the account holder, billing service address, or telephone number. To explain how this plays out, I'll defer to Director of our Special Victims Unit, Director Matt Hedden.
Again, good morning. My name is Matt Hedden. Just a little background about me. I have spent the last 30 years in law enforcement. The last 10 of those have been locating and apprehending child predators on the internet. Currently, federal law requires internet providers to notify law enforcement of child sexual exploitation on their networks. This report then goes to the National Center for Missing and Exploited Children, or what we call NCMEC, as a cyber tip. NCMEC then sends the cyber tip to each state's respective Internet Crimes Against Children task force, and that task force commander then hands those out to local law enforcement. Right now, there are 25 affiliated agencies under that ICAC umbrella for Kentucky. The Attorney General's Office received over 100 cyber tips last year, and Kentucky State Police received just over 1,000. Just for an example of how these cases would work out in terms of the progression, a cyber tip would be reported through NCMEC. NCMEC would then send it to KSP. KSP that would hand it out to, let's say, the Attorney General's Office, for instance, and we would have very limited information to go on in terms of investigation. Oftentimes, it is just a username that we're given on the front of this. We would then have to resolve that username to a user's account, find an IP address, find an email address, and all these processes are done through the use of administrative subpoenas. We are just asking for the necessary tools to assist officers in the noble effort and the difficult war to find these child predators.
Thank you, Mr. Chair.
I think we have a question. Oh. I do have actually a question. No one else does. I noticed, I spoke with you about this, Senior Counsel Schroeder. The bill uses the term reasonable cause as opposed to what we typically see in a Fourth Amendment issue regarding the terminology of probable cause. Can you explain to those that may be watching the use of that terminology? And I have a second follow-up, which I can ask now or I can ask in a moment.
Yes, first I'll go ahead and attempt to explain that. It is an unusual term that we don't typically see in our Kentucky Revised Statutes. That was a term that the 2009 General Assembly approved. We believe that it's between the two standards. However, when you have the evidence of the child exploitation going on along with the IP address, I think you're there for probable cause. So based on everything they have, that point, I think it's reaching that level. But as far as the term, that was selected in 2009 and then confirmed again in 2013. So we're not, just to be clear for viewers, that's not a term we've added ourselves. It's an existing statute.
Thank you for that clarification. And the second question I had was, as it relates to these administrative subpoenas, you're not necessarily searching anything, you're just obtaining information. Could you explain that to the viewers as well?
Yes, I appreciate that question. It's a great question. This, going back to the analogy of a license plate on a car, a police officer following a car can look at that license plate and look up who the car belongs to. We see this as similar fashion, that you have evidence of crime, you have a internet service provider, you have an IP address, and right now you can reach out to that internet service provider and just get the name or who that account belongs to. If you want further information, you're going to have to go ahead and go through the traditional route. So bringing it back to the car analogy, if you actually want to pull over and stop that car and do a search, you're going to have to go through and get your warrant and everything like that. Just as our director here, beyond the things that we listed, such as electronic mail address, internet username, once you start searching for the substantive things, it's going to have to go the traditional routes.
Thank you for that clarification.
Thank you.
Do I have a motion on the bill?
Motion.
We have a motion by Senator Wheeler, second by Senator Reed. Mr. Secretary, please call the roll.
Senator Carroll.
Vote aye and explain my vote, Mr. Chairman.
Limited to 2 minutes, please.
Mr. Chairman, we did have discussion on the possibility of expanding this, the ability to issue administrative subpoenas to local law enforcement. Local law enforcement has the ability to do this same thing. They would just have to subpoena through the prosecutor's office. So we didn't feel like it was probably the best decision to expand it that far, and that's why we left it where it is. But understand that local law enforcement does have the ability to do this with the traditional subpoena through the prosecutor's office. And my vote was aye.
Senator Deneen. Aye. Senator Neal. Senator Nemus. Aye. Senator Reed.
Aye.
Senator Stivers.
Explain my aye vote.
Yes, please, limit to 2 minutes.
I think Director Schroeder, or Senior Counsel Schroeder, said that this was defined in 2009. Just a historical perspective, the senator from Laurel was the chair of the Judiciary Committee in 2009. It just wasn't this senator from Laurel.
Senator Thomas. Aye. Senator Wheeler.
Aye.
Chair Storm.
Aye. Senate Bill 169 is reported favorably with the expression that same should pass. Thank you for your testimony.
Thank you all. Appreciate it.
See nothing else on our agenda. We have a motion to adjourn.
Motion.
Motion. We are adjourned.